And for more insight into the crisis in Los Angeles, Rachel Van Lanningham, Co-Associate Dean of Research, and Erwin R. Buchalter, Professor of Law and Southwestern Law School, joins us from the city. Professor, thank you so much for joining us. I want to tap, first of all, into your experience as a Marine attorney for many years. President Trump seems to have taken this to another level by mobilizing those Marines, 700, in addition to the National Guard that's already there. Is this still a legal move? The Marines were not invited either, and California's AG, as we know, has filed that lawsuit alleging sovereignty infringement.
Thank you for having me. Good morning. And I was a military attorney for the Air Force, not for the Marines, but I'm incredibly troubled and concerned by the president's deployment of active duty Marines to our nation's second largest city when it was unnecessary. This goes against hundreds of years of norms, of procedural safeguards, again, and an aversion against using federal troops, particularly active duty troops, in a domestic law enforcement policing capacity, because it smacks of authoritarian overreach. Instead, it was Governor Gavin Newsom's responsibility and duty to keep the streets of Los Angeles safe. And Gavin Newsom had thousands of National Guard troops who are authorized to engage in law enforcement missions and trained to do so at his disposal to use at his discretion. He had decided it was not yet necessary, and President Trump completely bypassed him in an unprecedented manner. We have not had the president deploying unilaterally not only National Guard troops federalized to work for the president, as well as active duty Marines against a governor's wishes since 1965, when civil rights protesters were being protected by the federal government against states that were abusing their civil liberties.
Professor, so if this federal versus state clash continues to escalate, how do you see it playing out in the court? Which side do you think that the court will likely to side with?
Unfortunately, because the statute that the president did use to federalize the National Guard troops over the weekend is broadly written. It's so broadly written that it gives vast discretion to the president to decide when the conditions are ripe to federalize, that is, take control of the National Guard and use them in case of rebellion, risk of rebellion, in the face of rebellion against the federal authority, invasion, or the failure to execute federal law. And because there were some violent factions of these protests, even though they were a small minority component, and local law enforcement was working very hard to deal with those, I think that because of the data out there, because of those facts, and because the law is quite broadly written and does grant great discretion to the president, I think the courts at the end of the day will yield to the president.
And Professor, I want to ask you about a possible technical legal matter as well. We know that LA's Mayor Karen Bass is asking demonstrators to do so peacefully and don't fall into the Trump administration's trap. So my question is, can the president retroactively use increased chaos caused by the very presence of the National Guard and Marines in the first place as justification for Title X and potentially the Insurrection Act?
Yes, and that's actually what I've written about, that exact fearful scenario, that by preemptively and prematurely taking away the resources of the National Guard from the governor, under whom they train and deploy and provide assistance to our local law enforcement, by circumventing the governor and pulling the rug out from underneath his feet and taking away those resources, the president created greater chaos, as Mayor Bass said yesterday, created greater uncertainty. And uncertainty is what you don't want to have when you have military members who are armed and trained in the use of lethal force. He added greater uncertainty, and there's been allegations that the violence increased because of that inflammatory move. Now, on top of it, you have an unprecedented use of active duty Marines from Camp Pendleton, just south of Los Angeles, being sent into a city when they are trained to fight our foreign enemies and trained in lethal force. Their mission set is not to engage in any kind of law enforcement. And yes, they're being sent in to help protect federal buildings. Well, there's thousands of other National Guard members that can do that, and thousands of Los Angeles Police Department, like County Sheriff's Department and California Highway Patrol, law enforcement assets that do this on a daily basis are trained, and they did not ask for this help. So it's a severely escalatory move that, as you said, could then lead to the conditions that, oh, President Trump now needs to invoke the Insurrection Act, which would therefore allow these federalized Guard troops and active duty to engage in policing, which is, again, it's anathema to how the United States works, deals with law enforcement and domestic policing. It would allow them to engage in searches, seizures, arrests. So you would have active duty military members policing the streets of Los Angeles, and that's a really horrific thought when it's not necessary. Also, this is quite disrespectful to those young men and women who have volunteered to serve selflessly in both our National Guard and our Marine Corps. You don't put them in harm's way unless it's absolutely necessary. You do not ask them to potentially use force against their own community, against other Americans, unless it's absolutely necessary. Compared to how these authorities have been used in the past, there is nothing here that says this is at all necessary. Instead, this is a message of intimidation. It's symbolic, and it's very dangerous.
Understood. Professor, we will have to leave it there for now. Thank you so much for your time this morning. Rachel Van Lanningham is Co-Associate Dean of Research, Professor of Law at Southwestern Law School, also a retired Lieutenant Colonel in the U.S. Air Force.